Part 2, 2024 contracts for the Illinois Bar. Next up, contract content and meaning. Modification. First up, what do we need for a modification? We need additional consideration, of course, and we also need mutual assent. To modify a contract, additional consideration and mutual consent, unless one, unforeseen circumstances make the modification fair and equitable to both parties, or the modification is justified based on a material change of position in reliance on the contract. Okay, normally you need consideration to modify a contract. You need mutual assent to modify a contract, unless unforeseen circumstances make the modification what? Fair and equitable to both parties, or to the modification is justified because there was a material change of position in reliance on the contract. Now, by contrast, under the UCC, what do we need for a modification? Just good faith. Okay, the parole evidence rule. Parole evidence equals outside evidence. Objective, four corners, plain language trumps subjective intent. A complete integration, which you never find on the bar, is one in which the parties intend for the agreement to be a complete and exclusive contract, and it's usually signaled with a merger clause. Partial integration, the parties will have an intent as to some but not all of the terms, and the contract will need to be interpreted. All right, it goes to court. No extrinsic evidence is permitted of, that's right, prior or contemporaneous agreements, unless they clarify an ambiguity, which would be construed against the drafter. There's evidence of a defense as to the contract formation, or there's some sort of separate or on-the-side agreement that's not addressed in the integrated agreement. Does the parole evidence requirement apply to subsequent oral or written communications? No. The parole evidence rule bars what? Prior or contemporaneous dealings or agreements. The parole evidence rule does not apply to subsequent dealings or agreements or subsequent communications. What's our exception? Sometimes, to clarify an ambiguous term which could be construed against the drafter who knew, evidence of some sort of defense, or a separate agreement, an on-the-side agreement. There's subject matter that wasn't addressed in the integrated agreement. But the basic parole evidence rule is no extrinsic evidence permitted in court of prior and contemporaneous agreements, but subsequent is okay. The parole evidence rule does not bar evidence of, under the UCC, course of performance, course of dealing, or trade usage in that order. Course of performance would be considered first, followed by the party's course of dealing, and 3, usage of trade can be considered. And excuse me, this is common law and UCC. So course of performance between those two parties, course of dealing, and finally, trade usage. These are admissible to fill gaps, resolve ambiguities, but they're not admissible to contradict or modify. If there's a contract, course of performance and course of dealing are going to take more weight over trade usage. Okay, let's review the parole evidence rule. Objective language trumps subjective intent. A complete integration is usually indicated with a merger clause. This is intended to be a complete and exclusive agreement. If we go to court, inadmissible prior or contemporaneous agreements, not subsequent agreements. Okay, course of performance, course of dealing, and trade usage may be admissible to fill gaps and resolve ambiguities, but inadmissible to contradict express terms. You cannot use parole evidence to contradict express terms. All right, we may come back to that and re-record this as a later date. Okay, performance and breach. Number one, conditions express or implied by law. Conditions mean a party's performance is conditioned on an event that doesn't occur. Therefore, there's no performance due and no breach. A condition precedent is a condition that must occur before performance can occur. A condition subsequent discharges a duty that already exists. And concurrent conditions are just one party's performance is conditioned on the others. All right, conditions. Define a condition. An event that doesn't occur such that no performance is due, and there is thus no breach. First up, let's define condition precedent. That's right, a condition that must occur before performance can occur. What about a condition subsequent? It discharges a duty that already exists. Okay, concurrent conditions. Each party's performance is conditioned on the other's performance. Conditions can be excused or waived. A condition can be excused when, number one, it's unjust to insist that the condition occur, or two, one party wrongfully prevented the condition from occurring. The condition is excused where it's unjust or one party made some sort of wrongful act that prevented the condition from occurring. Okay, conditions may also be waived by election or by estoppel. But let's move on. An accord is an agreement to forgive a prior contractual obligation, and it exchanges it for a new obligation. So an accord switches the obligation, forgives a prior obligation, exchanges it for a new obligation. This is a modification, so what does it require? Oh yes, consideration. So an accord switches the obligation. A novation switches the parties. A novation extinguishes or discharges the original contract. The original contract is no more. A novation adds a new party, switches parties, it discharges the prior contract and substitutes new contractual duties. So an accord switches obligation, a novation switches parties or adds a new party. Okay, if you're going to release someone from the contractual obligation, what do you suppose we require? That's right, a writing. How about if we just don't, both of us just want to rescind the contract? We don't want to perform. Well, if both parties agree on that, no consideration is required to rescind the contract, but after performance, we cannot have mutual rescission. There has to be some other type of remedy or defense. Okay, what about satisfaction? A satisfaction clause would be to my personal satisfaction on a matter of aesthetics. For an individual, that's going to be defined by that reasonable person standard. And if it's a corporation, the court will apply an objective standard. Okay, first of all, let's run back. Before we get to breach, we're going to run back through performance. Number one, conditions. Condition precedent. Condition must occur before performance can occur. Condition subsequent discharges a duty that already exists. A condition can be excused where it is one, yes, unjust, or two, one party did a wrongful act that prevented the condition from occurring. The condition can be waived by election or estoppel. What's an accord? An agreement to forgive a prior obligation in exchange for a new. Switch obligations. What do we need for an accord? That's right, consideration. A novation switches parties or adds a new party. The original contract is extinguished. It discharges that contract and substitutes it anew with new parties, adds parties, switches parties. What do we need to just release someone from an obligation? If we don't have consideration, we need a writing. Mutual rescission, is that okay? Yes, if there's no performance, we don't need consideration. What about after performance? There has to be consideration, a defense, or some sort of remedy. Satisfaction, personal satisfaction on a matter of, that's right, aesthetics. What standard do we apply to an individual? That's right, the reasonable person. What standard do we apply to a corporation? That's right, the objective standard. Okay, let's discuss breach. To prevail on a breach of contract action, the other side must show it was what? Ready, willing, and able to perform. Let's repeat. To prevail on a breach of contract action, the other party must show it was ready, able, and willing to perform. All right, we have our material breach, which is the failure to substantially perform all the duties under the contract. What does this do? It discharges the other side's duty to perform. So material breach is a failure to substantially perform all duties under the contract, and it does what? Discharges the other party's duty to perform. How do we determine what's substantial? Well, we look at it to the extent that the non-breaching party will be deprived of the benefits of the contract, can be compensated, or will suffer hardship. Substantial equals 1, the extent the non-breaching party will be deprived of the benefits of the contract, can be compensated, or will suffer hardship. Substantial, deprived of the benefit, is there compensation? Will they suffer hardship? And would the breaching parties be likely to cure the failure? And was their conduct in good faith? So material breach is a failure to substantially perform all duties under the contract, and it does what? Discharges the other side's duty to perform. Substantial. Will the non-breaching party be deprived of the benefit? Can they be compensated? Will they suffer hardship? What about the breaching party? Are they likely to cure the failure? What was their conduct like? Was it in good faith? Okay, what about a delay in performance? Can that be considered a material breach? Yes, if the contract stated time was of the essence and the delay prevented substitute arrangements. A delay in performance can rise to the level of a material breach If the contract stated 1, that's right, time was of the essence, or 2, that's right, the delay prevented substitute arrangements. Okay, then there is a partial breach. The non-breaching party has to complete their own performance, and they can sue for damages on the breaching party. All right, so if we have a partial breach, the non-breaching party is still required to perform. However, they may sue for damages. Partial breach, who can sue? The non-breaching party. What must they do? They have to complete their end of the bargain. Okay, divisible contracts. A divisible contract can be divided into multiple jobs, each paid on completion. What happens when one part of the contract is paid? It triggers the other side's duty to pay. Okay, so let's talk about anticipatory repudiation, our favorite. Absolutely, unequivocally refuses, will not perform. What can the other side do? 1, urge performance. 2, suspend performance and ask for assurances. 3, repudiate the contract themselves. If they don't get those assurances, they're excused from their own performance. They have an immediate right to sue. Someone says, I absolutely unequivocally will not perform. The other side may, number 1, that's right, urge performance. They may 2, that's right, suspend performance. They may 3, ask for adequate assurances in writing. And if none of that works, they are excused from their own performance and they have an immediate right to sue. All right, anticipatory repudiator, can you retract your anticipatory repudiation? Yes. Before the other party materially changed its position in reliance, or 2, indicates it considers the repudiation final. Anticipatory repudiation, someone wants to repudiate. You can, 1, urge performance. 2, suspend performance. 3, ask for assurances. 4, immediately sue. Can you retract your anticipatory repudiation? Yes, you can. Before the other side has 1, that's right, materially changed its position in reliance, or 2, indicates it considers the repudiation final. Okay, so let's talk about the UCC perfect tender rule. The buyer is, of course, entitled to perfect tender. Do they ever get it? No. So the buyer may accept in part, reject in part, or accept all and sue for the deficiency. Okay, so the seller also has a right to cure before time for performance has not been expired. They notify the buyer of their intent to cure, and they provide a cure in a reasonable time. Okay, installment contracts under the UCC. A person may reject a single installment if it substantially impairs the value of that installment and can't be cured. You can reject a single installment if it substantially impairs the value of that installment and cannot be cured. But you may not cancel the entire contract unless that one non-conforming shipment substantially impairs the value of the entire contract. So can you reject a single installment under the UCC? Yes, if it substantially impairs the value of that installment and can't be cured. What about the whole contract? You can't reject it unless the nonconformity substantially impairs the value of the entire contract. And of course, you have to notify the seller. Okay, the seller has a right to cure. When? before the time for performance has expired. 2, they notify the buyer of intent to cure. And 3, they provide the cure in a reasonable time. The seller's right to cure. When? Before the time for performance has, that's right, expired. 2, they notify the buyer of what? That's right, their intent to cure. And 3, cure in a reasonable time. All right, let's talk about risk of loss. FOB, free on board. If specified in the contract, of course, the contract governs. But under the UCC, for a shipment contract, the risk of loss passes to the buyer when the goods are delivered to the third-party carrier. You drop it off at UPS, Mr. Seller, the risk of loss passed to the buyer when the goods went to UPS. However, seller, if you say you're going to deliver by third-party carrier at a specific location, like the loading dock or the front door, the risk of loss passes to the buyer when the third-party carrier delivers the goods to that specific place. All right, simple terms. Shipment contracts. Risk of loss to the buyer when 1, goods are delivered to the third-party carrier, or 2, if the third-party carrier must deliver to a specific place, when does the loss pass to the buyer? When the goods get to that specific place. Risk of loss in a non-shipment contract depends on whether the seller is a merchant or a non-merchant. If they're a merchant, seller, if you are a merchant, the risk of loss stays on the seller until the buyer receives the goods. The risk of loss remains on who? The merchant, until the buyer, that's right, receives the goods. If the seller is not a merchant, the risk of loss passes to the buyer when the seller makes goods, that's right, available to the buyer at the specific place. Pick them up at the back door if you're a non-merchant. When the buyer picks them up at the back door, risk of loss. When you make them available at the back door, the risk of loss passes to the buyer. Okay, remedies. First, the common law remedies. Number 1, remember, remedies never cover attorney fees or punitive damages. Never, never, never attorney fees. Never, never, never punitive damages in contract law. Never. And there's always that duty to mitigate under the common law. Never what? Attorney fees. Never what? Punitive damages. And we always have a duty to, that's right, mitigate. Okay. Under the common law, our primary measure of damages is, that's right, expectation damages, to put the non-breaching party in the position they would have had the contract been fully performed. The non-breaching party is placed in a position in which they would have been had the contract been fully performed. Expectation damages as if full performance. What's our formula? Loss in value plus other loss. Loss in value plus other loss minus loss and costs avoided. Loss in value plus other loss minus loss avoided by not having to perform, plus costs avoided by not having to perform. Loss in value of the contract plus other loss minus loss avoided, the loss that you avoided by not having to do the contract. Costs avoided, materials you didn't have to buy, materials you resold. Expectation damages include incidental damages, meaning reasonable expenses. Special note, construction contracts. The damages are based on 1, diminution in the property's market price, or 2, cost to complete the performance or remedy the defect. But our basic expectation damages is loss in value of the whole contract plus other loss minus loss avoided by not having to perform, costs avoided, you didn't have to purchase those boards, plus incidental damages, your reasonable expenses. Reliance damages put the non-breaching party in the position they would have had they never entered the contract. And they are only awarded to the extent that they are, oh yes, reasonable. In other words, the court has discretion. Reliance damages put the non-breaching party in the position they had been had they never entered the contract. They are only awarded to the extent that they are reasonable at court's discretion. You cannot get reliance and expectation damages, nor can reliance damages be in excess of expectation damages. Restitution damages is available for unjust enrichment. The aggrieved party had the expectation of a benefit, and the breaching party has to give up any gains, say the down payment on a home. Can a breaching party get restitution? Yes, if the other party was unjustly enriched. Okay, what's a good example of this? A painter goes to paint a house, except he paints the wrong house. The guy who owns the wrong house stands by and watches his house painted. He knew restitution is available even though the painter breached by painting the wrong house. Okay, liquidated damages. Agreed in advance has to be a reasonable forecast of the harm caused by a breach. Cannot operate as a penalty or they will not be enforced. Liquidated damages, agreed upon in advance, reasonable forecast of the harm caused by the breach, enforceable unless they operate as a penalty. Specific performance. Money damages are inadequate. When is this really always an issue? Land, because all land is considered unique, but also for art or heirlooms, unique items. And the aggrieved party must have clean hands. Okay, rescission as a remedy. That returns the party to the status quo ante, returns them to the place they were before the contract ever existed. Basically, it allows a non-breaching party to cancel the contract as a remedy. So when would this happen? Remember, mutual mistake. We never had a contract. We never had mutual assent. Rescission is appropriate. How about fraud or undue influence? The non-breaching party remember that's voidable at the option of the non-breaching party. So it can be rescinded. So the thing to remember is rescission returns the parties to the status quo ante. Allows the non-breaching party to cancel the contract as a remedy. All right, one can also seek a negative injunction. Stop building, stop doing that as a remedy. Okay, let's get into the UCC remedies. We already talked about this, but they're important. The buyer's remedies, when the seller breaches. Cover damages. Contract minus cover at time of delivery. Market damages. Contract minus market at the time the buyer learned of the breach. Cover damages are what? That's right, contract price minus cover price at time of delivery. Market damages are what? Contract price minus market price at the time the buyer learned of the breach. How about the seller's remedies? What are their resale damages? That's right, contract price minus resale price. What about their market damages? Contract price minus market price at time of delivery. Okay, incidental and consequential damages. Buyers get incidental and consequential damages. Sellers never get consequential damages, but they do get incidental damages. Remember, incidental damages are just your reasonable expenses. All right, we're going to stop it here and we're going to get to third party beneficiaries, assignment of rights, and delegation of duties.